This has been an age-old debate, but one that still remains relevant and is being argued in the courts. Should Section 124A of the Indian Penal Code, which is the law against sedition, be removed from our statute books? The Supreme Court has heard this matter in the past and is doing so again to determine whether or not this law is constitutional.
I am not against it being altered. I'm not against it being tinkered with and made a more wholesome, better provision. But I'm against its scrapping altogether. I feel sedition as a law has a sound basis. But unfortunately, sedition in its interpretation by various governments is most unhealthy and wrong. I believe that it should be very clear-cut as to what sedition really is. And I think that is where there is a fundamental lack of understanding. The lack of understanding is because people assume that the terms government of India means a party which is in power at the center. I believe that the intention of sedition was something different. It was not bringing into hatred, disrepute, or contempt a given ruling party. In fact, the explanations to the Section 124A itself makes it clear that to bring about change by lawful means, that the purpose of this is really to criticize for the purpose of positive change, even if it is against what the government of the day stands for. That is not sedition. Sedition really is when you say something which brings your country, the country, what I call Bharat Mata, into disrepute or contempt. If I say something vilifying of my country, of that nationalism of my country, of the integrity of my country, of the sovereignty of my country, now that is where sedition comes in. It doesn't come into play when I'm criticizing, however harshly, the government of the day, criticizing policies, however harsh, of the government of the day, or criticizing even a manner of performance in any manner at all. That, according to me, is not sedition.
Freedom of speech in India is not absolute. Article 19(1)A of the Indian Constitution, while guaranteeing the fundamental right to free speech and expression, is subject to reasonable restrictions.
If you read Section 124A, it talks about speech, written or unwritten, spoken or written, which has the effect of causing contempt, etc., and has the effect of disturbing or causing annoyance to the government by laws. There is a distinction between a government in office running the administration and government by laws. And this distinction has been spelled out by the Supreme Court itself as far back as in 1962, followed by the next case, Balwant Singh in 1995, and a very recent judgment, June 2021, in the case of Vinod Doa. Government by laws, the Supreme Court has held, would be relatable to the symbol of the state as distinguished from the government in office. Right? Section 124A deals with that government, the government by laws established, the state.
Article 19(2) of the Constitution lists out the restrictions in question, and these are in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency of morality, or in relation to contempt of court, defamation, or incitement to offence. There is an entire gamut of laws in India that regulate free speech. Section 153A of the IPC is aimed at curbing hate speech or speech promoting enmity between groups. Section 295 of the IPC is aimed at preventing offence to religious sentiments. And there are provisions within the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act that draw the line over what can and cannot be said against members of the communities concerned. Section 499 and Section 500 of the IPC criminalize defamation.
I think so far as freedom of speech is concerned, it is the basis. According to me, freedom of speech is the basis. It's a fulcrum of a democracy. If you don't have freedom of speech, you don't have a democracy. And for me, the most valuable fundamental right way of democracy is your freedom of speech. But there are restrictions which have been laid down in the Constitution itself as to such freedom. And I think those restrictions are correct restrictions, and those restrictions are very clear. And those are the only restrictions which can be brought about against the freedom of speech. For example, if the sovereignty of India, it is the integrity of India, anything which is against public order, which is going to cause some kind of riot, some kind of public disorder of the nature, which is not just a law and order problem, but much wider. If you notice, Article 19 2 does not refer to law and order, it refers to public order, which is far, far, far wider. So I think the Constitution is very clear that freedom of speech will not be restrained except in the rarest of rare cases found in the restrictions in Article 19.2. And I feel it is perfect as it stands. It should continue as it stands. And of course, you will have cases where cases will be filed saying that this is a restriction on my freedom of speech, and the court will consider whether it's a fair restriction, a reasonable restriction or not. That will be done on a case-to-case basis, and that you can never stop. But what I do believe is, as Article 19.1a stands and 19.2 stands, I think it is absolutely clear that your freedom of speech is a vital, important fundamental right. It can be restricted only in very rare cases and very extreme cases.
Sedition, however, has divided opinion more than most because it was frequently used by the British to imprison those campaigning for India's freedom. This includes Bal Gangadhar Tilak, Mohandas Karamchand Gandhi, among a whole host of others. Sedition was introduced in the Indian Penal Code in 1870. Tilak was charged under sedition once in 1897 and several times more, which entailed a 6-year imprisonment for an editorial published in his newspaper Kesari. Gandhi too faced similar charges much later, and in 1922 said, and I quote, Section 124A, under which I am happily charged, is perhaps the prince among political sections of the IPC designed to suppress the liberty of the citizen. Stop quote. After independence, and at the time that the members of the Constituent Assembly were deliberating over the shape and form the Indian Constitution should take, there was a consensus that the word sedition would not be included in the Constitution as a restriction for free speech. But things changed when the First Amendment to the Indian Constitution was brought in by the interim Parliament before the first general elections in 1952. This amendment was introduced by India's first Prime Minister, Jawaharlal Nehru, and once incorporated in the Constitution, reversed many of the liberal and progressive steps taken during the Constituent Assembly debates. It revived sedition as a basis for restricting free speech. As author Tripudaman Singh writes in his book 16 Stormy Days, the story of the First Amendment of the Constitution of India, and I quote, Section 124A of the Indian Penal Code, which deals with sedition, is today cited as a remnant of British colonialism, now misused as a means of silencing dissent. Yet, not even its most prominent critics ever note that the founding fathers of the Constitution of India did not intend for it to remain on the statute books. It had found no constitutional support in the original Constitution. It was revalidated in 1951 despite intense opposition by the introduction of new grounds under which free speech could be curtailed, the interests of the security of the state, rather than undermining the security of the state or overthrowing it. Far from being a simple remnant of colonialism, sedition is an outcome of the First Amendment of the Constitution and the Nehru government's desire to clamp down on critical voices unencumbered by constitutional obligations, a truly deliberate and strategic assault on the Constitution and fundamental rights. Stop quote. The Nehru dispensation at the time was being criticized on multiple fronts. It had lost cases in the higher courts over clamping down on the freedom of press. It was also facing serious resistance in the courts over its passage of zamindari abolition laws, which came under scrutiny over questions about the constitutionality of some of its provisions. It also faced heat in the courts over the introduction of quotas in educational institutions in the southern states. Ironically, it's Nehru's Congress that is today calling for the scrapping of the law against sedition, and the legatees of Shyama Prasad Mukherjee, who was Nehru's most vociferous opponent during the debates on the First Amendment and spoke out strongly against its provisions, are now defending the sedition law as necessary. That's the BJP, which now heads the government. The sovereignty and integrity of India is sacrosanct, but it is the vagueness of Section 124A and its susceptibility to rampant misuse that has raised concerns. The Supreme Court has deliberated on the constitutionality of this section and upheld it, though added riders against its misuse and mentioned the circumstances in which it can be invoked. It said in the Kedarnath judgment of 1962, and I quote, "As already pointed out, the explanations appended on the main body of the section make it clear that the criticism of public measures or comment on government action, however strongly worded, would be within reasonable limits and would be consistent with the fundamental right of freedom of speech and expression. It is only when the words, written or spoken, etc., which have the pernicious tendency or intention of creating public disorder or disturbance of law and order, that the law steps in to prevent such activities in the interest of public order." So construed, the section, in our opinion, strikes the correct balance between individual fundamental rights and the interest of public order. Stop quote.
The court may lay down guidelines, but then tomorrow it's always open to two lawyers to try to interpret what those guidelines would mean in a given case, which is why I did not say that there should be guidelines for the use of the weapon of sedition against seditious people. That is why I said the act has to be amended. The statute itself has to be amended. The section as it stands should not continue, but the section should be suitably amended, not just on basic guidelines, but suitably amended to specify what exactly will amount to sedition, make it very clear, and nobody can go beyond that. I feel that there should be an amendment of the statute in order to bring out very specific areas, demarcations, and there should be no confusion. But above all, what should be kept in mind is sedition is not the offense intended when criticizing the government of the day or its policies or what it's doing. Sedition was meant to be there only when you were attacking the very integrity of the country itself. Now, that is what needs to be brought out very clearly through amendment.
The crux of the petition is that 1962 Kedarnath Singh, that's a constitution bench judgment, okay, 5 judges, is over a century old, and time has come to have a new, fresh look, whether Kedarnath Singh requires a relook. That's why perhaps the Chief Justice and the bench and his companion judges thought, let's have a second look at it. That's all.
Simply put, there ought to be a direct attempt to incite violence for the law to be invoked. But these guidelines haven't really stopped governments from misusing the law or perversely being liberal in its invocation. In 2013, a Maharashtra government led by the Congress and the NCP slapped a sedition case against cartoonist Asim Trivedi. In 2020, following dissent within the ranks of the Congress, sedition was invoked by the Rajasthan government against its dissidents. In 2021, Disha Ravi was slapped with a sedition case by the Delhi police over presentations made to mobilize support for the farmer protests in the national capital. In the Disha Ravi case, in which the respondent was the Delhi police under an NDA government, the court that granted her bail was quite scathing in its observations about the Delhi police's action, saying that the offence of sedition cannot be invoked to minister to the wounded vanity of governments. According to the National Crime Records Bureau, there were 70 cases of sedition filed in 2018 with 0 convictions. In 2019, 93 sedition cases were filed and there were only 2 convictions. In 2020, 73 cases were filed with no convictions. Moreover, the United Kingdom scrapped its own sedition law in 2009, while India continues to have it in its statute books and uses it quite extensively. Not only is sedition the topic of heated debate now because the Supreme Court is hearing petitions to strike it down, with the centre mounting a defence for its retention, but also because a case under sedition has been filed by the Maha Vikas Aghadi Sarkar in Maharashtra under the Shiv Sena, the NCP and the Congress against independent Member of Parliament from Amravati, Navneet Rana, and her husband MLA Ravi Rana after they pledged to recite the Hanuman Chalisa outside the residence of Maharashtra Chief Minister Uddhav Thackeray.
किसी पर राजद्रोह लगाने का कानून पूरी तरह से परास्त किया जाए, माननीय शरद पवार जी कह रहे हैं हलफनामा देते हुए भीमा कोरेगांव कमीशन से। और दूसरी ओर दोगलापन देखिए कि उन्हीं की महाराष्ट्र की सरकार राणा परिवार पर राजद्रोह का मुकदमा दर्ज किया। उन्होंने दोगलेपन की भी हद होती है। दुर्भाग्य से महाराष्ट्र की सरकार ने ओछी राजनीति के लिए वे सारी सीमाओं को पार कर चुके हैं।
Sedition, important laws like sedition laws should not be abused. There should not be political abuse of sedition law, and we should be very careful when we apply or when we use sedition law.
Sir, but the way in which this Hanuman Chalisa row and loudspeaker row is going on in Maharashtra, what is your reaction over that, sir?
All these are with a political intent. It is unfortunate using any religious issues for politics itself is a crime.
Unfortunately, so-called secular syndicate की समस्या ये है कि वो खुद कंफ्यूज हो रहे हैं। उनका कंफ्यूजन का मुख्य कारण ये है कि मोदी जी के आने के बाद कहीं पर जो है भागलपुर नहीं हो रहा है, कहीं पर भिवंडी नहीं हो रहा है, कहीं मलियाना नहीं हो रहा है, कहीं मालेगांव नहीं हो रहा है जहां कत्लेआम होता था। सन 84 जैसे सिखों का नरसंहार नहीं हो रहा है, आतंकवादियों के मुंबई के हमले नहीं हो रहे हैं, दिल्ली के हमले नहीं हो रहे हैं, अजमेर के हमले नहीं हो रहे हैं, मक्का मस्जिद जैसी घटनाएं नहीं हो रही हैं।
Interestingly, this coincides with Sharad Pawar, the head of the NCP, which is a key constituent of the Maharashtra government, submitting before a panel looking into the Bhima Koregaon violence that Section 124A of the IPC should be scrapped. One of the flashpoints that triggered a debate around sedition was the violence and protests witnessed in JNU in 2016. The trial in those cases is continuing, with the likes of Umar Khalid and Kanhaiya Kumar being given bail after being booked under sedition charges. As the question around the constitutional validity of the sedition law has once again reached the doors of the Supreme Court, what really can we expect? The Supreme Court has upheld laws like criminal defamation where they have been challenged in the past. Can misuse of a law alone be the basis for its scrapping? There are hundreds of laws in India that are vulnerable to misuse. So is that a strong enough reason for the law to not exist altogether?
There are two things. One is the legality of the law. The other is the legality of exercise of powers under the law. If a law is legal, then there is no ground to strike down the law. If a law is legal, but people who are vested with the responsibility of implementing the law are wrongly implementing it, then strike down their implementation of the law. But you don't throw the baby out with the bathwater. You don't say this law is being implemented badly, therefore I'm going to strike down the law. Rather, correct the wrong implementation of the law, which is why I say I am for sedition, the offense of sedition continuing, but not in the present state. I want the offense of sedition to be clearly outlined. I want the act to be amended, to be clearly outlined as to what exactly will amount to sedition, and not give any play in the joints or any discretion thereafter to given governments to try to interpret it and misuse it. I want it laid down very clearly that 1, 2, 3, 4, 5, these are the actions which are sedition and nothing else for the purpose of 124A.
Every law is capable of being misused. The possibility of misuse, to my mind, is not enough to scrap a law. The government in its wisdom may drop the law, but the standards by which the government judges are different from the standards that the court judges. The court judges the legality of the legislation. The government judges the necessity of the legislation. This is the fundamental difference, and that is why the Chief Justice, in using those words, had desired to know what is the view of the government. Does the government feel the necessity of continuing the law? If, of course, the government comes up with an opinion or with a view that the law needs to be continued, the Chief Justice and his bench would then have to consider the legality of the legislation from the standpoint of the permissible jurisdiction of the Supreme Court.
Moreover, India has faced serious challenges to its sovereignty and integrity, and lives are being lost to preserve it. At a time when parts of Jammu and Kashmir continue to remain on the boil, as do some parts of the northeast, and there is an attempt to revive the Khalistan movement on the part of anti-social elements, can a free run be given to those who want to chant anti-India slogans or make public pronouncements for secession, with there being a clear and present threat that this could descend into violence? At the same time, if a law is being used rampantly to settle political scores or interpreted with a deliberate intention to suppress genuine criticism, should it not be revisited? All eyes are on how this now pans out in the highest court of the land.